Hi there, I'm James Appice, and this is Coffee and a Case Note. Team, indeed. Today we're going to be taking an adventure into the exciting world of self-managed superannuation funds. Wackadoo! So we've got Dad, and we've got Dad's second wife. And in 2005, Dad and his second wife set up a superannuation fund, and Dad and his second wife are the trustees and the beneficiaries. Time passes, and by the time we get to around about 2014, Dad's son from a previous marriage is Dad's financial manager. He is also Dad's power of attorney, and pursuant to a deed, he comes to replace Dad as the co-trustee of the super fund. Can I get that on your head? 2005, we've got Dad and second wife as trustees, beneficiaries of the super fund. Flash forward to 2014, we've got son and second wife as trustees of the super fund. Sadly, something like a year later, Dad passes away. That's about 2014. And time passes after that, and Dad's executor starts to get involved. Now, probate of Dad's estate is granted in about 2017, and in about 2018, what we have is Dad's executor and Dad's second wife entering into a deed between themselves, purporting to say, oh, by the way, when Dad died in 2015, son stopped being a trustee of the super fund, and Dad's executor started being a trustee of the super fund. Now that's really fiddly, so I'll hit you with another summary if I can. We've got Dad dying in 2015, second wife and executor say, bing, immediately on Dad's death, son stopped being a trustee of the fund, bing, executor started being a trustee of the fund, right? The proceedings we're talking about today is our son being the plaintiff. He's seeking declarations to the effect, in essence saying, nah. In essence saying, I remain a trustee, Dad's death didn't stop me being a trustee, and also the executor was not validly appointed as a trustee. Hope that makes sense. So the court had to grapple with sort of three issues that were intertwined. In essence, did the son stop being a trustee on Dad's death? Was son appointed trustee in his personal capacity, or was he appointed pursuant to the powers of attorney? And third issue, was executor validly appointed as trustee? Now, some of you will be jumping into your phones or jumping into your earbuds now, shouting out the answer. With respect, I think you're about to shout out the right answer, so let's work through that. Was son appointed in his personal capacity? Was he appointed as a trustee in his personal capacity or in his capacity as attorney? Well, as you're jumping out of your seats or jumping into your phone to tell me, he was appointed in his personal capacity. The Powers of Attorney Act here in New South Wales governs that, and I suspect there's similar legislation and similar law elsewhere, in effect stating that an appointment as a trustee cannot be effected pursuant to power of attorney in the way proposed in this matter. So, personal appointment as trustee. Did that appointment stop on Dad's death? The answer to that is intertwined with that power of attorney point, because the answer is no. So Dad's death, which had the effect of extinguishing the power of attorney, did not extinguish son's trustee appointment, because, as we just agreed, that trustee appointment was not pursuant to the power of attorney. So son's personal capacity, trustee appointment, tick. Son remains a trustee on Dad's death because his appointment is not extinguished by the power of attorney being extinguished. And three, executor is not validly appointed retrospectively back in 2015 because appointments of new trustees have to be made pursuant to the trust deed, and this purported appointment that second wife and executor tried to put in place was not validly made. So we have son getting the declaratory relief he wanted, which is to say the court saying, yep, you were a trustee, yep, you are a trustee, and so all the documents and accounts and that sort of thing for the super fund now need to be delivered up to the son, who now finds himself in a position as joint trustee with the second wife. Quick sketch today. I hope it assisted you, and even though some elements of it you might have found a little bit clear, I think you'd agree these are fiddly concepts, and I hope I assisted you having a fiddle with them if they affect you and as they affect you in future. Hope you have a great day. I look forward to joining you again soon for another coffee and another case note soon. Cheers.